Mhm. Okay. Good morning and welcome to the Regulation and Discipline Committee meeting of the State Bar. As a reminder, this meeting is being recorded. I don't know if Justin is here with us on
I am
Zoom.
here.
Okay,
I'm via Zoom.
got it. Justin, if you could take roll call, please.
Sure. Broughton,
Here.
Chen,
Here.
Cisneros,
Here.
De La Cruz, Duran,
Present.
Seleg,
Here.
Shelby,
Present.
Soul,
Present.
Stallings. Okay.
Looks like Ms. isn't here with us just yet. Okay,
Okay. We have a quorum.
thank you. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. And for those of you who are here by Zoom, you can use the raise your hand function.
We have one.
Currently, there is one member of the public, Pete Bennett. Once your microphone is unmuted, you will have 3 minutes.
And then I will note Mr. Stallings is now present.
Greetings. Can you hear me, folks?
Yes, we can.
All right. My name is Pete Bennett, resident of Contra Costa County since 1978. Some of my story passes through Jonestown. Some of my story passes through the Caldecott Tunnel explosion. My friend was blamed for that explosion. Some of my story passes through PG&E. I'm the witness that explained to the FBI how they blew up the pipeline. My attorneys get beaten, as I've already shared. My attorney, Dax Craven, disbarred. My district attorney, Mark Peterson, disbarred. My attorney, whose office was burned down in 2001, disbarred, Donald Gene Motes. My attorney, Sage Sahapi, beaten up by somebody in Walnut Creek, most likely a police officer. I'm an integral party to the Contra Costa Narcotics Task Force called cnetscandal.com. And on there, you search the word attorney license profile, and you'll see the list of attorneys that I'm planning on filing disciplinary charges on. I was attacked when I was writing an amicus brief with the PG&E hearings in 2019. I was nearly killed in the Walnut Creek Public Library. This is how justice works in this state. Every one of the law firms involved in the PG&E explosion are connected to the explosion in Walnut Creek that killed 5 people. Because the girlfriend in the Amber Alert story, her brother was driving the tractor. All right, the corruption is so bad that people are losing their lives. I have children. I intend to bring all these attorneys out. I want them out. I want the Bar Association in Contra Costa shut down and rebuilt. I want to file a claim against them. I have been denied access to counsel for 30 years. I hired prepaid legal, and they fell apart on me. My attorney didn't show up in a courtroom because they're being
And your
attacked.
time is up. Thank you.
Yeah, sure.
Anyone else who wishes to make public comment?
There is no one else with their hand raised at this time.
Okay, thank you. So we'll proceed to the rest to our agenda. In the interest of time, I will forego our chair's report. We do have a lot to cover on today's agenda. So we'll move to the consent calendar. Is there any member who wishes to pull an item off of the consent calendar? Okay, hearing none, we'll move to the first item, item 2A, open session minutes from January 20th, 2022. Are there any corrections or modifications to the open session minutes?
I'll move the minutes, Madam Chair.
I'll second.
Thank you. Motion by Duran, second by Cisneros. Justin, could you call the roll, please?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Yes.
Selig,
Abstain.
Shelby,
Aye.
Soel,
Aye.
Stallings.
Yes.
The motion passes.
Thank you. The first item on the regular agenda is item 3A, proposed amendments to rules 5.127 and 5.155 of the rules of procedure. And this is a request to circulate for public comment. We will hear a presentation from Erica Doherty and Michelle Crampton.
Good morning, thank you. So the State Bar Court is requesting a public comment period for 2 proposed amendments to the rules of procedure of the State Bar. The first being Rule 5.127A, which is a rule concerning reprovals that are ordered by the State Bar Court. The second is Rule 5.155F, as in Frank, which that subparagraph of the rule addresses when a hearing judge may be temporarily elevated to serve in the review department when the sufficient number of review judges are not available for disqualification or other reasons. Speaking to 5.127A first, the amendments will clarify that a reproval takes effect 60 days after the filing of a State Bar Court decision, opinion, or order, and this will provide sufficient time for a party to file an appeal. The amendments will also clarify that if a request for a review is filed in the California Supreme Court, a reproval, if that is upheld, will take effect 30 days after the filing of an opinion or order by the California Supreme Court. And that's pursuant to established rule, Rule 9.18A of the California Rules of Court. The second amendment is very simple. It is to amend 5.155F to remove the language of the Supreme Court. So currently under the existing rule, only hearing judges that were appointed by the Supreme Court may be temporarily elevated. This small change would allow for any judge who is in the hearing department, including those appointed by the legislature and the governor, to be elevated to the review department as needed, again, on a temporary basis for a particular case. I'm happy to answer any questions on either of these proposed amendments, and we're seeking a 45-day public comment period for these proposed changes. Thank you.
Thank you. Any questions?
Madam Chair, this is Brandon. I'll move the item.
Thank you. Motion by Stallings. Second by De La Cruz. Any discussion? Okay. Justin, oh, thank you for pulling up. We see the resolution now up on the screen. Justin,
Okay.
could you call a vote, please?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Aye.
Selig,
Yes.
Shelby,
Aye.
Soel,
Aye.
Stallings.
Yes.
It passes.
Thank you. Next up is item 3B. This is a proposed amendment to Rule 5.80 of the Rules of Procedure. This is a default procedure for failure to file timely response. This is a return from public comment and a request for approval, and presenting on this will be Chief Trial Counsel George Cardona.
Good morning. This is back. It was on the November 2021 agenda before the board, where we requested a 45-day public comment period. The rule as it is currently drafted provides that a motion for entry of default has to be supported by a declaration establishing one of two things, either that a signed return receipt for the notice of disciplinary charges was received from the attorney, or if not, that the deputy trial counsel took those additional steps a reasonable person would have taken under the circumstances to provide notice. The proposed amendment basically removes that second prong and instead substitutes a much more specific set of steps that the trial counsel is required to take to demonstrate that there is a likelihood that the attorney received notice. And it has provisions setting forth what proof can be provided of that and how that affects the burden of production in terms of establishing notice and permitting the entry of a notice of default. It went out for 45-day public comment period. We received no public comment, and as a result, we are back recommending that the committee adopt it.
Any questions, discussion?
Madam Chair, I'll move the item.
Thank you. Motion by Stallings,
I'll second that, Madam Chair.
second by Duran. May we have a vote?
Justin, you're muted.
I apologize. Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Yes.
Selig,
Yes.
Shelby,
Aye.
Sewell,
Aye.
Stallings.
Yes.
Motion passes.
Thank you. Next up is agenda item 3C. Mr. Cardona will also be presenting on a proposed amendment to Rule 5.21 of the Rules of Procedure concerning the limitations period. This is a request to circulate for public comment.
Actually, this is a return from public comment and a request for approval of
Oh, my
the
apologies.
amendments to Rule 5.21, which addresses the rule of limitations. This was before the committee on January 20th of this year, 2022, at which point it was authorized for a 45-day public comment period. The amendments are a variety of amendments to the rule of limitations that at a high level, we believe would ensure that we have the necessary time to investigate complaints in particular that are submitted by complainants at or near the 5-year limit by creating a rolling 2-year period if a complaint is submitted close to that. In addition, there are some clarifications about tolling while an attorney owes a fiduciary duty, tolling during the pendency of related civil, criminal, or administrative actions, some cleanup regarding review and reopening of complaints and how that affects the rule of limitations, and a clarification that the independent source exception applies even if the state bar is notified of the independent source by a complainant, and the addition of some examples of what constitutes an independent source to provide additional clarity in the rule. So those are some of the amendments. They're summarized at length in the discussion that was before the committee in January and which is attached. The one public comment that we received during the period was a letter that was submitted from the Professional Responsibility and Ethics Committee of the Los Angeles County Bar Association. The comment had a general request that the board refrain from adopting these proposed amendments or any other revisions to or new regulations relating to the disciplinary system until the ad hoc commission on the discipline system has completed its work. It also had an objection more specifically to one of the amendments, contending in particular that the amendment essentially generally created a 7-year rule of limitations instead of 5. With respect to the specific comment, I think, as I've explained, it doesn't just generally substitute a 7-year rule for a 5-year rule. Rather, it creates a rolling 2-year period if a complainant, who most often are individuals who are not represented and may not understand the rule of limitations, submit something close to that 5-year limit to provide us with an opportunity to investigate it and avoid a situation where we would have to dismiss simply because we don't have time to follow up and investigate. With respect to the more general request that there be a deferral until after the ad hoc commission has engaged in its review of the disciplinary system, As we note in the agenda item, we're not aware of anything before the ad hoc commission that specifically relates to the rule of limitation. And so believe that there's no basis for delaying adoption of this rule. On the other hand, if the committee believes that that's an appropriate thing to do and it wouldn't delay this significantly, we wouldn't object. So our preference would be that it be adopted now, particularly since there's nothing the ad hoc commission is considering that directly relates to this. And with the understanding that if the ad hoc commission comes back with recommendations that suggest a different modification, we can always do that at that time. So with that, we'd submit it and ask for approval of the amendments.
Mr.
Thanks,
Slade?
George. I wasn't at the last meeting, so I didn't have time to discuss this, but I'm a little concerned about the independent source change. And so for everyone that's following this, I'm looking at page 10 of the red line version of the rule. So that seems to me a little concerning because the 5-year period is already extremely long, I think, by comparison to criminal statutes of limitations, but you would know more. And then we have all these 2-year tolling provisions, some of which I think are going to be frequently invoked. And there are problems with allowing claims to be brought very lengthy. So what this amendment to the independent source concept says is that at the 4-year, 11-month mark, if the complaining witness identifies some other person who has evidence that neither the bar nor they came up with during 5 years of investigation, that another 5-year period commences. And that just doesn't seem right to me, but let me have your thoughts on it.
So currently we have an independent source exception. So if an independent source exists, so for example, if separate and apart from a complaint, for example, there's a court opinion or some other independent source for the information. Right now, there is no limit. There's just simply an exception. The limit doesn't apply to disciplinary proceedings investigated and initiated by the state bar based on information received from an independent source. What this is intended to do, and this is something that has come up in the past, is on occasion we will get complaints submitted by, for example, academics who have gone through and done reviews of court cases and have identified court cases that have made certain findings and bring those to our attention. And this is intended to address that situation and allow us to treat that as an independent source, which it is, the court opinion or other similar type of document or similar sorts of findings, even though that independent source has been identified to us by a third party. So that's what this amendment is intended to accomplish. I don't think it, in other words, I don't think it will work. It's intended to clarify rather than to significantly change. In other words, I think we could take that position now, but this will make that clear.
Yeah, right. So the scenario you laid out seems reasonable, but I think the rule as amended is much broader than that because it doesn't require, in that case, it is truly an independent source, right? Because some third party has done an investigation and the complaining witness has learned about that. So that seems fair enough. But if it's someone the complaining witness knew about and just didn't tell the bar for 5 years, that just seems concerning. What I would propose, if you're okay with it, is maybe take this piece of the amendment out of this package and let's look at this language a little bit more, because your explanation to me seems valid, but I do think that's the proposed language is much broader than the kind of rationale that you've offered.
And so I would be okay with that. I would just note that, that's one of the reasons that we included some examples of what constitutes an independent source. An independent source may include a court order opinion, a judge's report pursuant to Code of Judicial Ethics, Canon 3D2, or a media report. So the intent of those examples was to try and make more clear that it's not just, a complainant finding someone else to submit a complaint. There has to truly be an independent source for that information over and above a third party.
I think what would be helpful, and I don't want to even attempt to wordsmith here, is some kind of definition of what it means to be an independent source, because I think that's something that people could debate quite a bit. And probably do.
understand, and
cases.
there are alternative ways we could word this, which we did consider. So if there is a desire to work on language on this one in particular, we could basically remove this amendment and pass the rest of them.
That would be great. And I'd be happy to work with you and any other board members interested to see if we can come up with that.
So, I mean, I don't have a extreme objection to that. So
Okay.
if that's the committee's choice, I'm happy to do that.
So with that, I'll move to adopt the item with the amendment that the changes to proposed rule 5.21 G are omitted from today's motion.
And just so it's clear, so 5.21 G would remain in its wording as it currently is.
Correct. Better stated.
I'll second the motion.
Okay, motion by Seleg, second by Stallings. And Mr. Seleg, just so I'm clear, is your concern not so much that there are these examples that are given of what an independent source may be, but rather the phrase, even if the state bar is notified of the independent source by a complainant?
Well, it's the latter clause that kind of got my attention.
Yeah,
And then I think the fact that the examples are merely illustrative and don't really provide a definition is a problem. So, so I think the wording could be improved.
got it.
And if
Okay.
I can just add, in terms of the wording, my intention in working with you would be to exclude. I don't think we can come up with an exhaustive list of what independent sources are, but to exclude the example you've given of a third party simply basically recruiting another party to submit the complaint on their behalf.
Right, understood. Yeah, we can talk it through. I'm sure we can come up with something.
Madam Chair, I have a sort of administrative type question, and that is, if this passes as amended, Mr. Cardona works on some language to satisfy the concerns raised here, would that result in another opportunity for public comment on the change to the rule if there's change?
Yes, I believe we would have to come back with what would essentially be another amendment to 5.21 G that would be subject to the public comment and then approval process.
So
Okay.
maybe it makes sense to withdraw this item if we're going to have to come back to it anyway.
I think
What's
we-
the practical
I
effect?
think we might have to come, in other words, if we make a substantial change to G, we may have to send it out for public comment again anyway.
Yeah.
So I'd prefer to get the other amendments adopted, and then we can simply come back and work on G as a
Yeah,
separate
There are
amendment.
several, yeah.
And then send G out for public comment again.
Yeah, I
After we-
support that.
after we work.
Because there's no
Yeah, that
reason to
makes
delay
sense.
the rest of the package.
Okay, thank you.
Okay, further discussion?
Madam Chair, I just wanted to thank the members of the ad hoc commission for their continued work on issues affecting the discipline system, and just echo what Mr. Cardona said as far as us moving forward on some changes that have already been in the works for a while. Certainly does not preclude the ad hoc commission from continuing to discuss these issues and to bring those issues to the board's attention. So I guess I see this work as the board is continuing on with the help of the ad hoc commission and really advising us on what their study reveals. And neither one necessarily is competing with each other, but we're both working towards the same goal of improving the justice system.
Thank you. Further discussion?
So just to make sure that I should do attachment A with the exception of 5.21 G.
It would, the attachment A would still have 5.21 G, but it would be modified to be the current language of section 5.21 G.
So Justin, how about after attachment A, comma, provided that subdivision G, capital G, I think,
Yeah, capital G.
shall remain unchanged.
So,
And Madam Chair, I just have a question. The reasoning behind not withdrawing this entire piece until 21G gets cleaned up, 5.21G gets cleaned up is
So I think because we'd have to
Is it
go
time
through another board,
sensitive?
it's to put this rule change in effect now, instead of holding it up, because it, I think it does do a lot to protect the public, to allow investigations to proceed for that 2-year time period when things get raised towards the end of that window.
Yeah.
Okay.
And, in some situations, I think subdivision G is totally severable from the rest of the package. So, it's not like, I don't see an interrelationship with the rest of the changes.
Okay.
So if we think the rest of the changes are good policy, there's no reason to delay implementing them.
Okay, thank you.
Sure. Further discussion? Okay, shall we call a vote?
Broughton,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Duran,
Aye.
Sleg,
Yes.
Shelby,
Aye.
Sowell,
Aye.
Stallings.
Yes.
The motion passes.
Thank you. Next up is item 3D. This is a discussion of the application of the consumer alert policy to criminal complaints alleging felony charges. And this will be presented by Mr. Cardona.
So
Before we go, Madam Chair, before we go farther, I have to abstain or to recuse myself from this item. So I will, I guess, put myself on.
Okay. Oh, you muted yourself before you finished your sentence.
I think he's,
Okay, so Mr. Bratton's going to abstain from this. Go ahead, Mr. Cardona.
so if the committee recalls, in November of 2021, the Board of Trustees adopted proposed amendments to the board policy regarding posting of a consumer alert upon the filing of felony charges against an attorney. And that amendment clarified that we could post the pending consumer alert when a felony charge was pending either in California, US courts, or any state or territory of the US, and authorized a revision of the language to refer the public to the jurisdiction in which the felony case was pending. When that modification was made at the meeting, a request was made to us to return with additional information to clarify, for purposes of the consumer alert, what it means for an attorney to be, quote, charged in court with a felony, and in particular, how the consumer alert is applied or whether it should apply to criminal complaints as opposed to criminal informations or indictments. So the agenda item that we've provided you gives you that information, which is essentially that under both California and federal law, an attorney is considered charged with a felony when a criminal complaint is filed. It does initiate criminal proceedings on the charge, and accordingly, our current practice is to post the consumer alert when a criminal complaint is filed and when we learned of it. In addition, we've pulled 2 sections of the Business and Professions Code that we believe are consistent with this. One is Section 6101B, which requires prosecutors to notify the state bar of the pendency of any action against an attorney charging a felony or misdemeanor immediately upon obtaining information that the defendant is an attorney, not limiting that to an information or indictment, as opposed to other sections of the State Bar Act that do limit it to informations, do limit self-notification requirements for attorneys to informations and indictments. In addition, Business and Professions Code Section 6086.1C requires the State Bar, notwithstanding the confidentiality of investigations, to disclose to any member of the public who may inquire any information reasonably available pursuant to a number of subdivisions of the State Bar Act, including 6101, which is the requirement that prosecutors report the pendency of any criminal charge. As a result, we believe that posting consumer alerts when we are aware of criminal charges, even if those are the result of a complaint, is indeed consistent with these 2 provisions of the State Bar Act. And we recommend that this remain our practice. So this is for informational purposes. Interestingly, it's responding to an issue that was raised by Mr. Broughton, who has now recused himself. But the information regarding complaints and how they proceed and their status as criminal charges in both California and in the federal system are included in the agenda item. I'm happy to try and answer any questions.
Thank you. And just to clarify, this is an item for discussion only. It is not for vote. And so I don't know that abstentions are needed. And I mean,
If I may, Madam Chair, I'm going to pretend I'm the GC for a little bit. If it's a recusal, right? So even though there's not a vote, Mr. Broughton's not participating in the discussion. He should put on the record the reasons for his recusal.
okay. So
Sorry,
this is a recusal and not an abstention because there is not a vote. Mr. Broughton, if you could make sure you're unmuted and explain the reasons for your recusal.
Because since, and you all should know if you've been around that I've been rather vocal on this issue since it first came up. But since the last meeting and last discussion on this, I currently represent an attorney with which this issue is being dealt with. So I don't believe that I can be fair and impartial, at least ostensibly, in discussing or voting this on this item.
Okay, thank you. Questions for Mr. Cardona, discussion?
I have a question.
Yeah.
So, Mark, I'm so distressed that you're recused because I was going to ask you to explain us to your concern again, because I'm feeling a little at sea with this.
Believe me, I'm dying to get into this, but I did discuss it with Vanessa and things. I think the most prudent approach is for me to recuse.
So,
Sean,
can I ask? Oh,
Sean, I can provide a counterpoint. you know,
yeah,
to the best
kind
of
of
my
crystallize.
ability.
Is it just whether what's described in here as a criminal complaint should result in the consumer alert? Or is it more complicated than that?
I think
That-
that,
My understanding is that that is the question.
Okay.
In other words, whether a criminal complaint, in other words, in California, a criminal complaint starts the initiation of the process. But we could, in theory, learn of it before there's been a preliminary hearing at which the judge would make the determination after the preliminary hearing of probable cause.
So that's should the triggering event be the complaint or a finding of probable cause at preliminary hearing? Or whatever
Although
the finding
there are
is.
findings of probable cause prior to a preliminary hearing as well. In other words, once someone makes an initial appearance under a Supreme Court case, a magistrate has to make a probable cause determination for a warrantless arrest. And under California law, if there's an arrest warrant issued on a criminal complaint, that has to be supported by a finding of probable cause as
Okay.
well.
But the difference is between merely the district attorney making that conclusion versus a judicial finding.
No, in each of those cases, both for an arrest warrant and upon initial appearance, it would be by a magistrate, which in California would essentially be a judge. Is my understanding, and Mr. Stallings can correct
Yeah,
me,
maybe-
but I don't
yeah.
think California maintains a different magistrate system.
I also think the difference is in California, there are many crimes that can be charged as wobblers. And so a criminal complaint can be filed, but it's not until the preliminary hearing. And I think this is the issue that Mr. Broughton had raised previously. It's not until the preliminary hearing that there is a probable cause finding to hold the defendant over to answer to a felony. And so it's the issue that the consumer alert says this person's been charged with a felony, but an argument could be made that that finding is not reached until post preliminary hearing. And in the meantime, the criminal complaint can have been filed and is sitting out there, which under the rules as interpreted here would trigger that consumer alert being posted. But you could argue that it's not really a felony until there's been that probable cause finding by a judge post preliminary hearing.
Again, Mr. Stallings can correct me, but I would, if it's charged as a wobbler, then it's charging facts that would support a felony charge. And if there is a magistrate's finding to support that finding of probable cause, it would be probable cause for either the felony or the misdemeanor.
And I'm sorry, charged as a wobbler. What does that mean for us lay people?
so there are
Sorry.
certain charges you could be charged as a felony charge or as a misdemeanor. So for instance, criminal threats is one of the most infamous wobblers. It can be charged as a felony. And then it can also be charged as a misdemeanor, depending upon the facts involved in the particular investigation. So a court can, after the preliminary hearing, reduce a felony charge down to a misdemeanor based upon its review of the evidence. There's case law to that effect. So I don't know if that answers.
So I do think, I mean, I I do think that one difference is that the probable cause finding for an arrest warrant doesn't get into necessarily the nitty gritty details of whether it's a felony or misdemeanor. And that is
That's-
what would be considered at a prelim.
That is correct. In other words, the judge who's issuing the arrest warrant would not be making a determination in their discretion as to whether it should be reduced to a misdemeanor. It would simply be finding that there is probable cause for the set of facts that support the charge. I will say, as a practical matter, the vast majority of criminal charges that actually come to our attention, given delays in notification and other things, are informations or indictments. But on the other hand, looking at the business and profession codes, they seem to make clear that even if we didn't post a consumer notice, we would be obligated, if a person inquired, to provide them, if we had received a notice of a criminal complaint charging a felony or something that could be a felony as a wobbler, we would be required to let them know that, in fact, we had that information. And typically, my understanding is that we have treated inquiries made by accessing the website as being equivalent to an inquiry. And so that's one of the reasons that we believe we should maintain our current practice of posting that. And obviously, if a court were to determine that it was more appropriately charged as a misdemeanor, we would be required to take down that notification.
And Madam Chair, if I could just add,
Yeah.
so Business and Professions Code 6101 sub B places an obligation on a district attorney, city attorney, or other prosecuting agency to report criminal charges to the state bar. And is not limited to whether the charges are brought by indictment or information, but rather prosecutors are obliged to report the pendency of any action against an attorney charging a felony or misdemeanor immediately upon obtaining information that the defendant is an attorney. So from a practical standpoint, you could have a situation where you have a lawyer who's arrested. In the probable cause declaration, there could be a listing that the individual is a lawyer. The district attorney's office would review that complaint request. And the way I read the statute is, upon the district attorney receiving that information and then making that determination on how they're going to charge that case, whether it's a felony or a misdemeanor, then I think at that point, the district attorney would then notify the state bar. So there would be an extra level of discretion exercised by the district attorney's office in making that judgment call of, should this be a felony? Should this be a misdemeanor? And then essentially transmitting that to the state bar. So it's not just you have an arresting agency out there saying, oh, this is felony conduct. Now all of a sudden the state bar is notified. That's not the way I read the way the state bar is notified. Have we received any, Mr. Cardona, have we received any notifications from law enforcement agencies independent of district attorney's offices?
I can't say definitively, but I will say that we have enough difficulty getting notifications from the prosecuting agencies. We regularly send out letters reminding prosecuting agencies of their obligation to report. We very often do not learn of something until there's been a conviction.
I think one of the cases that really brought this to the attention of the board was former trustee Danette Myers, who's a supervising DA out of Los Angeles. She had prosecuted a lawyer for murder and was distressed to find that that lawyer had not been reported to the state bar. So sometimes things, fall through the cracks, and prosecuting agencies definitely have a lot on their plate, and there's a business and professions code that directs them to make such notifications. So I've spoken at length with Mr. Broughton about this topic, and I think that there's always going to be two sides to this discussion. I think the state bar, we do what we can to make sure that that individual, that lawyer, does have a fair trial. And even in our disclaimer, we say that the filing of criminal charges does not constitute a finding of guilt or professional misconduct. Criminal defendants are presumed to be innocent until proven guilty in a court of law. And I think that goes to satisfy some concerns that Mr. Broughton has raised.
Madam Chair, Mr. Cardona, has the special ad hoc committee weighed in on this issue? The discipline committee, I'm sorry.
I know I know the committee you're referring. So I don't think the ad hoc commission has specifically addressed the consumer notification. They have been addressing when discipline that is imposed is posted on the website, when that should be removed. And there have been some proposals for earlier removals of actually imposed discipline from the website. But I don't, and I apologize, I have not been at all their meetings, but I don't believe that this has come up specifically.
I guess I would direct that to the ED.
It has not come up specifically, but the broader topic, as George indicates, has been addressed, meaning the issue of what is publicly posted on the website. And further, will there be a more expansive expungement process afforded to respondents? So nothing specific to consumer alerts, but the broader issue of what we put on the website on an attorney's profile certainly has been a topic of conversation by the ad hoc commission.
Okay, any further discussion? All right, we appreciate the additional information, Mr. Cardona. Next on the agenda is item 3E. This is a presentation on preliminary risk assessment, attorney supervision, and assistance redesign project. The presentation will be provided by Bridget Grammy and Lori Mellick.
Good afternoon, everyone. I'm Lori Mellock, the Program Director of the Office of Professional Support and Client Protection. I'm here to provide information about the State Bar's Attorney Supervision and Assistance Redesign Project, what we refer to as the ASAR project. It's intended to update and redesign the procedures and approaches of the Office of Case Management and Supervision Probation. Office of Case Management, Supervision, and Probation, which was formerly known just as the Office of Probation, monitors respondent attorneys who are on probation pursuant to Supreme Court discipline order or who have to comply with disciplinary conditions pursuant to a State Bar Court approval. The procedures of the office are being looked at and redesigned to try to utilize techniques more like those used in criminal probation that are evidence-based or evidence-informed to help direct how attorneys with disciplinary conditions are monitored and supervised. The goal of the project is to provide more directed interventions for the respondents. We want to try to identify the causes of the misconduct that brought the respondent under State Bar supervision, and then use these targeted interventions to try to address those needs. In this way, we can better protect the public and hopefully prevent future misconduct and reduce recidivism. One of the key pieces of this redesign is the creation and use of a risk assessment tool. So today we are presenting this informational item to update you all on the work that is being done to create this risk assessment tool. The State Bar has retained data analytics experts, Drs. Michael Baglivio and Kevin Wolf of Analytics Initiatives, to analyze relevant data and determine if there are predictive factors that can be used to create a risk assessment tool, which can then be used to help direct how we monitor respondents with disciplinary conditions. Dr. Baglivio and Dr. Wolf are appearing remotely to present information on what a risk assessment is, how it works, and to share some of their preliminary findings based on the data that they have been reviewing. And we also have available for questions Brian Richart, who is our consultant on this project, who is the Chief Probation Officer of El Dorado County. So with that, I will turn it over to Drs. Baglivio and Wolf, and they can make their presentation.
All right. Thank you for the opportunity to speak to you today regarding this project. I am Mike Baglivio, and you'll hear from Dr. Wolf in a few moments. The intent of our component of the project that was just mentioned is to develop a standardized tool that will assist in categorizing clients with respect to the risk for recidivism, talking about new complaints, new investigations, and new filings.
So most likely going to be into low, moderate, and high risk classifications. Additionally, the tool is going to provide guidance into the areas that make each individual client most at risk. So what makes this client higher or lower risk? So what particular factors, meaning that the tool is standardized, but also individualized to allow for best addressing those unique needs. Now, this slide here, traditionally, across disciplines, risk is determined by either clinical or professional judgment. For instance, in criminal justice or juvenile justice settings, like Lori had mentioned, a probation officer would leverage his or her experience, whatever available documentation there was, and discussions with the client to arrive at some notion of how risky that probation officer believed that individual to be for future offending. Now, naturally, that creates a situation wherein a determination of risk is dependent, obviously, on the probation officer working with the client. All of my biases, notions of what makes somebody more likely to reoffend, who trained me, et cetera, would lead me to arrive at a much different likelihood of reoffending than a probation officer with different lived experience or different background training, et cetera. So that sets up a situation where the same client or similarly situated clients would be treated differently in the system based on who they were assigned to. So that could create disparities in restrictiveness or oversight of sanctions, et cetera. So notably, this is true in other disciplines and fields as well. You could imagine banks approving a business loan or a home loan, a small business loan, disparities that could result from personal biases in approval, amount approved, or terms. So this idea of creating standardized assessments transcends disciplines and fields. Structured assessment corrects for these issues, providing a more accurate and equitable assessment, as Dr. Wolf will talk about in a few moments. So next slide, please. So risk assessment then can help guide decisions and assist with the allocation of scarce resources. So the simple risk principle would dictate to us that higher risk individuals more likely to reoffend, to get into trouble again, should receive more intense services for a longer period of time. So the duration and the intensity of services, right, than lower risk clients. So a greater focus on those who pose the most risk of getting into trouble. And that determination in our project is based on your data, your clients, prior individuals who's gone through your system, not some other system or some store-bought risk assessment. It's based on your data. So that's pretty important. I'll pass it over to Dr. Wolf to talk about specifically how we're doing that for this project.
Sorry, unmute. Thanks for having us here. So as Mike mentioned here, we'll be developing a risk tool using data provided to us from the State Bar. That includes probation cases over the last 10 years. And we're going to use items drawn from a number of data elements from your organization to develop a risk score for each of those individuals, and then assess how that risk score is connected to recidivism, which we also have measures of new complaints, new investigations, and new convictions of those individuals. The nuts and bolts of this are to assess the relationship between each of the measures and the outcomes, and then combine and weight them in some way, which will be transparent and made available to everyone, in order to generate a risk score for each individual. It's very important that that risk score is predictive of recidivism in a real fashion, and that we can use that to guide some of the provision of services down the line. Of course, there are concerns of racial and ethnic disparity here with the use of risk assessment. That's a broader issue across disciplines, including the juvenile justice system. There are ways to protect against this. That's by not using a canned risk assessment and assessing the items across race and ethnicity, right? So if those items can be predicted by race and ethnicity, there are potential problems. A quick example here is if your indicator is mental health needs, or mental health diagnoses, the presence of a mental health diagnosis, just 0, 1, that sounds okay. That sounds like a risk factor. But what goes into that item of mental health is actually very important. We see in our own work in juvenile justice that youth of color are way more likely to be diagnosed with conduct disorder, specifically, not more serious mental health disorders. If you were to include conduct disorder in the scoring item on mental health, you'd almost certainly bias that tool, making youth of color higher risk, because that item has bias within it. So that is one concern, of course, that we're aware of. And so in this project, we will be assessing all the relationships with race and ethnicity for each of the items. Two example items just to kind of wrap up our presentation here today. These were drawn again from data from the State Bar of California. One is restitution ordered, and the second is prior alleged failure to perform duties, which is kind of a combination measure. There's a chart here that may help to identify or to explain this idea of risk. So there are two sets of bars here. One is the group which had no restitution ordered while on probation. Again, these are your clients from the State Bar on probation. We see rates of recidivism 59, 46, and 26% based on those three measures of recidivism. The red is new complaints, the blue is new investigations, and the gray is new filings. Among those clients that did have restitution ordered, however, we see a pretty substantial jump in recidivism across all three categories, between 19 and 21% higher risk of recidivism among those attorneys that were ordered to pay restitution. More broadly, so we're using items drawn from data on probation. Many of these include conditions of probation, right? So we are limited in the fact that the court has ordered these conditions for these probationers. This stuck out as a decent item that is predictive of recidivism. The second one, as an example here, is prior alleged failure to perform duties. Here we have more categories: individuals with 0 prior allegations, those with 1 or 2, those with 3 or 5, and those with 6 or more. This is a composite measure of lots of different failings. So allegations or complaints of failing to cooperate, failing to maintain membership, failing to report filing of 3 lawsuits in 12 months. There's a pretty good list here. It isn't inclusive of all prior allegations items provided by the State Bar, but it was one that showed a pretty clear indication of risk. So again, we see a pretty linear pattern across all 3 outcomes here, where individuals with more priors are more likely to recidivate. These are just 2 examples. I think there's about 70 measures in the data set that we're examining and producing a detailed report on each of those items, which ones we believe, well, which ones demonstrate to be related to recidivism. And then there most likely will be quite a bit of discussion about which ones are appropriate for the weighting and combination into a risk tool. So that's the 8-minute version. But we're happy to take questions.
Thank you. Questions, comments?
Do you want to talk, Lori, a little bit about how this is, when it's developed, how it's going to be used?
Sure. So what we're going to be doing is, after the State Bar Court recommends the conditions of discipline, the probation case specialist will set up an initial meeting with the respondent, under which they'll go through the conditions. And we're also undergoing motivational interview training for our probation case specialists and creating an intake guide, so that in working with the respondent, they can try and elicit information that will help inform the risk assessment. There will be static factors, data that we have about the respondent that will be included. But then also in interviewing the respondent, the idea is to try and build a rapport and see if we can determine, why do you think you got in trouble here? What was going on? Did you need help in your law practice? Do you have an underlying substance use issue that maybe has not been identified yet? If they're willing, of course, to talk with us about that and get that information, we can then target the interventions to them. But anyway, we get the information, it's then plugged into our risk assessment based on the questions that are developed working with our data analytics experts. That will then come out with a score of whether this person is high, low, or medium risk. And that will help just the probation case specialist determine How often do we need to meet with this respondent? Do we need to set interim goals for them so that they can meet the conditions of their probation along the way and not wait to do everything at the very end when everything is all due? Should we have them reporting more frequently to us? Or is this someone that seems like they're on the right track and maybe they don't need to report as frequently and we can focus our resources somewhere else? So that's sort of what we're trying to create with our whole framework that we're developing.
Thank you. Mr. Sewell, you have a hand up.
Yeah, just I appreciate the presentation, and I appreciate the discussion of the inherent sort of biases that can be part of sort of the use of risk assessment tools. I'm familiar with this in the policymaking context as it relates to bail reform and how you apply bail. I guess my questions are sort of twofold. One is, or two. One is there another tool that's sort of in circulation that folks or other states or other jurisdictions may be using in this context? And two, whether or not when ultimately developed, will this be the sole thing that folks are using in order to make some determinations?
So I'll just take the first question. In our research, we have not found that there are other states who are using a risk assessment tool for their respondents, which is why we're starting really from scratch and working with our experts to try and create one for ourselves. And in the second question, the State Bar Court will still be making the ordering the conditions at the beginning based on everything that they went through in the discipline process to get there. The probation case specialist now will be reviewing those conditions and in interviewing the respondent, determining if there are other things that we need to add or for any reason, anything that would be recommended to be taken away, and going back to the State Bar Court and asking them to order those new conditions that we think would be relevant based on what we've learned from the risk assessment for the respondent. So there is due process built in there, and that the court will still have to order it and the respondent will have an opportunity to respond.
And my next question is sort of, and what are we foreseeing as sort of a time frame in terms of development?
We're hoping to have this developed within the next few months and then begin implementing as soon as we can get essentially the court. The court has agreed to start to change their condition language to allow use of the risk assessment, to order that the respondent has to participate in it. And so we have been working with the court already on language for that. And again, we're hoping within the next 6 months or so to really have this going.
And would this come back before the full board prior to its implementation?
No, it's not currently slated to.
You mean for decision or for presentation as to the results of this analysis?
I think understanding the risk here of using a risk assessment tool, I personally would like to hear a little bit more about what has actually been developed and what some of the inputs are, and actually before this actually is fully implemented.
We can certainly do that. I just want to make sure the board understands that under the status quo, we have significant racial disparity in our system, and we have a highly ineffective system. You saw the recidivism rates on your screen there. So I don't want any members of the board to be under the misimpression that continuing with the status quo is somehow necessarily better than implementing changes which I think, yes, there are some concerns about using risk assessment tools, but there are also concerns about what is effectively our current approach, which is a fairly cookie cutter model. We have a large number of conditions for our respondents, sort of irrespective of the underlying issues that they present. That's not best practice, and we should not sort of fool ourselves that it is. So happy to bring things back, want to make sure everyone is comfortable, but I don't want to sort of sugarcoat our status quo.
And just want to piggyback on that, because I think I just want to make clear that we have a clear understanding of what this risk assessment tool is going to be used for. From Ms. Millock's description, it sounds like it's not being used in any punitive way or to sanction. That is the job of the state bar court based on the full panoply of procedures and evidence presented. What this is intended to be used for is to try to prevent recidivism. And that is helpful to the attorney by identifying, factors that may cause, them to be high risk, and to implement additional meetings or additional check-ins or just working more closely with them to help them satisfy the conditions of their probation and the like.
And conversely, sorry, I'm talking so much, but this is an issue I'm really passionate about. Things like written quarterly reports. We have to question why we are requiring that, how it is tied to addressing the issues that brought somebody into our discipline system, why we would be requiring quarterly reports of all of our respondents. So just like the risk assessment may add conditions of probation and extra supports or requirements, as Lori mentioned, but I want to emphasize, it may also result in a recommendation to reduce the conditions of probation as well.
Thank you. Mr. Duran.
Just a general comment that I think all of this ultimately is to the good in the public protection aspect of what we do, right? Both in the disciplinary piece of it, but in the preventative piece of it that you just mentioned, Chair. I think like many of us, I saw the eyes widen when we saw that the recidivism slide, and for those attorneys who have been forced to pay restitution, they're the highest recidivators. And I'm assuming, and this is where it's dangerous to let a lawyer try and be a statistician or a data analyst. Is that because the cases where restitution is ordered are sort of more serious cases, and it's just that type of violator who is going to continue to violate? I don't know if it's fair to ask that question, and it's causation correlation type issues, but it piqued my curiosity.
And I think that's some of the things that we'll be discussing more. I think Dr. Baglivio, you had pointed out another area where we saw a sort of a converse thing was with the people who were had lap conditions, right?
That's correct. There, and Kevin can talk better specifics, but the issues with around some substance abuse were less likely than other folks. Now, so you see the condition of restitution. We're not in any way suggesting that by ordering restitution, you're increasing the likelihood someone would reoffend, right? Obviously, or doing the assistance program would increase, but rather it gives them. So in the substance abuse issue, the assistance program gives people the treatment, the services that they need to address a condition, that therefore reduces the likelihood of reoffending. And most likely, you're right, we don't have causation yet, but most likely that's what's going on. And then conversely, the restitution issue is those would be the more serious cases, or it could be differences in one, I have a personal issue that I'm dealing with, the substance abuse issue, whereas a restitution order could be related to some type of some theft, some funds going missing, some things like that. That could be different type of offenses and different types of individuals committing those offenses.
Thank you.
Mr. Stallings.
So Mr. Broughton and myself have been the trustee liaisons to this working group. So we want to thank staff and our experts for all of your very thoughtful work in this area. Really excited, as Madam Chair just talked about, the reducing recidivism piece and trying to work to a place where we reduce potential public harm as much as possible through this tool. One of the interesting topics that we talked about in our last bi-monthly meeting was this issue of restitution and the term of probation. And I think this is an issue that is going to go before the ad hoc commission. So it's a good example of how the Board of Trustees is working to improve the discipline system, and then giving to the ad hoc commission various things to study and see ways that we can continue to improve. So I just wanted to thank staff for their thoughtfulness in that. I just do want to ask though, do any of these recommendations reduce the state bar's ability to try and collect restitution on behalf of injured parties, or does it change restitution orders in any way?
So currently, like the data they're studying is just to help us inform how the probation case specialist might approach someone who has a restitution condition. What we would have is sort of a list of interventions that the probation case specialist would use. That if someone is in this circumstance, maybe we can recommend this to help them through that. And some of this would also be, the respondents sometimes wait until the very end of their term to try and pay all the restitution at once. So the goal would be to work with the probation case specialist and say, let's put you on a program. If you can do $100 a month, even if the court maybe didn't order them, they just gave them the lump sum at the end. If in working with the respondent, we can get them on a program to try and keep up a little better, and they build that rapport with the probation case specialist to see how that will help them to succeed at the end, then maybe we can help to improve those kinds of things. Now, of course, some of it is the person just can't afford to pay. At a certain point, there's not too much we can do other than maybe make suggestions for ways that they can, if they're suspended, that they can get a job in the meantime or things like that. There are some things we're not going to be able to address except with some common sense, discussions with them, hopefully. But there are interventions that we're going to be proposing that hopefully will help with keep them on track, essentially.
Okay. So I think that, given how this is a change in how we'd be doing things, I do think it'd be useful to see the results of the final analysis and the recommendations that flow out of it.
So it sounds like we'll bring the tool back for the board when it's finalized.
Okay.
And maybe be able to give some examples of how it would be used.
Yeah.
Yes, and very quickly, just to sort of follow up with what Brandon said, and also what Leah talked about, is that when looking at this information, we're looking also towards fairness. In other words, being able to tailor terms to an individual instead of having these broad-based terms that apply to everybody and may or may not work. The other thing that I like Arnie and like Brandon, we're used to dealing with these risk assessments in the criminal courts all the time with respect to bail review and that type of thing. I'm not a 100% fan of it. I should say that right up front, because not everybody fits into those boxes exactly, but it is a tool to be used. And one thing that I was worried about was that we would have enough data in order to have some good predictors. So I'm a little bit encouraged that we're going to at least go back 10 years and that we'll have that amount of data to look at, so that when we come up with a final product, hopefully it'll be of benefit to us in regards to things that we're looking at.
Okay. Thank you. Anything else?
Well, I just would like to take a moment. Lori is going to be retiring this year in May, I think shortly after our May board meeting, but I'm not sure you'll be coming to present to us in May. So I wanted to take a moment just to recognize you and all of your work and adaptability. We're focused on the Client Security Fund for a long time, and then we gave you a lot more under your portfolio. And as I think you've demonstrated today, you've taken that on really capably and with enthusiasm and interest. And so I want to recognize you and appreciate you. Wish you the best of luck and happiness in your retirement.
Thank you, Leah. Appreciate that. Well, thank you for your time. Thank you to our experts who are online here. We appreciate it. And I think that's it for this item. Thank you.
Yeah, thank you all. Okay, next item on the agenda is item 3F. This is an informational item. It is a report from Chief Trial Counsel George Cardona on the random audit of the Office of Chief Trial Counsel case files that are closed between March 1, 2020 and August 31, 2020, as well as the Office of Chief Trial Counsel response.
Thanks. So I think, as you likely recall, in November of last year, we made our first report on our semi-annual audit of closed cases. We've now implemented procedures that require us to do this on a periodic basis as we get the audits, to provide the committee with an executive summary of the audit that is prepared by the auditor in a way that can be presented in open session. So it removes specific case identifiers or other personal information. as well as our response. And so this is what will be a periodic event when we come before you. And this is presenting the report on the random audit of files that were closed between March 1st, 2020 and August 31st, 2020, and our response to that random audit. So I will answer the first question that I'm sure I would get, which is why are we only now reporting on files that were closed between March and August of 2020? And the reason is that the audit was delayed significantly by COVID. We are trying to catch up. So we are back. We were back in November, and now it's only 3 months later. We're trying to catch up, and we are actually now working on the next audit of the next 6 months. And so we expect to be coming back to you on a fairly regular basis until we get caught back up again. So we have attached to this the similar summary of the audit that was prepared by the auditor for you with the results of that audit and our response. We've laid out in the agenda item some of the primary points, and I'll just touch on some of those briefly and then try to answer any questions that people may have. So one of the things that the auditor does on a regular basis is assess whether there are files that were closed that in the auditor's view were improperly closed, that is in violation of OCTC policies or procedures, or in some instances based on a conclusion that it was an unreasonable assessment. In this case, the auditor recommended that we reopen 10 files, 3.9% of the total files examined. That's similar to the last audit, 3.1. We have gone through those files, the 10 that were recommended for reopening. We learned that one of those files was closed on the merits when it actually should have been closed as a duplicate of another file. So because it is a duplicate, that is remaining closed, and although for different reasons. And so in essence, we are reopening 9 files, which is 3.5% of the total of 255 files audited, which is essentially in line with prior audit results. The auditor did recommend that we follow up on an additional 6 files to determine whether that follow-up suggested things that would suggest to us that they should be reopened. We're in the process of doing that, and we'll then assess whether any of those additional 6 files need to be reopened. One of the discussions that we addressed at length in the agenda item from the audit was the auditor's view that we pursued domestic violence related crimes as crimes of moral turpitude per se, despite some contrary rulings from the State Bar Court Review Department. We've tried to explain to you why we take that position based on Court of Appeals decisions that in fact suggest the Court of Appeals review that even for disciplinary proceedings, those should be treated as crimes of moral turpitude per se. We do realize that that is contrary to the review department's current position, but when we do set it out, we set out our position and explain that it is in fact contrary to the review department's position, but that we believe it's correct because of the rationale that's used in the Court of Appeals, the California Court of Appeals decisions. The other thing that was touched on by the auditor in particular was some of the delay in the prosecution of criminal conviction cases. We recognize that delay. That is, and we believe, the result largely of the fingerprinting project that was done and the kind of bulge of older criminal conviction cases that have come through as a result of people getting fingerprinted and us learning about those for the first time. We do have ongoing procedures in place where we now do get notice on a more regular basis based on fingerprints of what's occurring. So we're hoping that that bulge won't occur again. And we are trying to clean up that. We do have additional staff that are dedicated to trying to complete our efforts to get through that kind of group of cases that have come in so that we can get back to a more normal processing time for criminal convictions. There was also some discussion of our handling in particular of DUI cases and older DUI cases. And we have looked at that. We do have policies and procedures in place that we believe people are following. They are fact specific. They do require an assessment of the particular facts surrounding the DUI and determining whether to make referrals. And we do believe that people are complying with those policies and procedures, but we will, in light of the audit's recommendation, make a special effort to ensure that those are both followed and that there's some indication in our case management system of the reasons why those cases are being referred consistent with those policies. That brings us to some of the more technical findings. The auditor once again noted Inconsistencies in our closing letters and memos. This is something that was noted in the prior audit as well. We recognize that this is an area in which we need to improve. We have recently modified some of our templates to make it easier for people to be consistent and prepare those letters. We will continue to see if we can find ways to ensure that there's more consistency across those memos and letters. The other thing was documenting files in Odyssey. This audit was of files that were closed in 2020. We have made significant changes, improvements in our systems for entering data into Odyssey, and I think people have become more familiar with it. So our hope is that as audits go on, as we move forward in the files that are closed, that this will be decreased. We do recognize that this is also something that we need to work on to ensure that our case management system accurately reflects what's happening in the files for a whole host of reasons, not least of which is that that's what we use to track and monitor and try and sort out if there are things that we should be doing differently or that we're doing wrong. So this would be a benefit to everybody to get this straightened out. Finally, there was discussion of deficiencies in some charging memos, closing letters, and investigation plans. We've again recognized that this is again a consistency issue, a thoroughness issue. We are working on this with supervisors and staff. And again, our hope, this has been something that has been identified previously. It has been worked on since 2020. We will continue to do that and hope that we can address that. In terms of training, there were a number of specific areas of training that were recommended. We don't have any disagreements with that. In particular, we are already planning training this year on the rule of limitations, which will be adapted to reflect the amendments to the rule that were just made, and client trust violations, a continuation of the beefed up training on client trust account investigations and prosecutions that was begun last year and is continuing this year, including rule 1.15, and potentially, should the amendments to that be recommended and adopted, the amendments to that rule and how they affect our investigations. So that's a short summary of the audit findings and our response. We've given you the more detailed summary of the audit. So at this point, I'll just open it up. If there are any questions, I can try and address them.
Thank you, Mr. Cardona. Recognizing how late it has gotten, if Chair Duran will permit, perhaps we could take a short break to get lunch and continue working through lunch and come back with questions and discussion after we've gotten lunch and brought it back in.
Sounds like a plan to me.
Okay. How long should we take, do you think? I know folks need bio breaks and the like.
Yeah, maybe 10 minutes. Oh, are we going to eat lunch on the break or eat lunch?
Eat lunch during discussion, but
yeah, exactly.
Shall we say 12:50?
Yeah,
to make it a round number?
Sure. 12 minutes.
Yeah, it's very late. So we'll come back at 12:50.
12:50, great.
Okay. Thank you. All right, everyone, welcome back to the open session of the Regulation and Discipline Committee meeting. Just before we broke for lunch, we heard a presentation from Mr. Cardona on the random audit of OCTC closed files. And now we'd like to open it up for questions from Mr. Cardona or discussion.
Thank you for the report, Mr. Cardona. You had mentioned that in response to some of the findings of the random audit, that there's trainings that you're offering in the office. I'm wondering, are they targeted trainings to sort of, are you finding specific staffers who are making the mistakes, or is it optional training for everybody? Could you expand on that a little bit?
It's a combination of both. To the extent the auditor's report identifies case/staff specific issues that require training, we address those to the individual staff. There are also areas in which she addresses general topics, or she addresses training that we believe would be of more use to the office as a whole. And so we also do office-wide training. So for example, the trainings that I mentioned that we're planning on the rule of limitations, client trust accounts, and the one other topic that I mentioned, those are all going to be office-wide. There will also be reach out to certain specific staff with respect to specific issues that are raised in the audit report.
Great, thank you.
Just wanted to call attention to the issue being litigated between OCTC and the State Bar Court relating to domestic violence and whether or not that constitutes a crime of moral turpitude per se. And I think it really does highlight the judicial independence that the State Bar Court has, and that just because OCTC says that they read a law or a statute a certain way doesn't necessarily mean that the State Bar is going to go along with it. So I think that's an important point, especially for the protection of public, that the public can be confident knowing that there is that judicial independence of the State Bar Court. And with that said, whenever there's a consistent disagreement between OCTC and State Bar Court, what is the remedy if there's some sort of, I guess, disagreement with State Bar Court and what other statutes or rather what case law says should happen in a particular case? What's the remedy?
Ultimately, the remedy would be if a case goes up on appeal to the Supreme Court could resolve that issue. So if, for example, one of these domestic violence cases were to go up and the Supreme Court were to resolve that one way or another, that would be binding on the State Bar Court as well.
Are there any cases that are currently before the Supreme Court relating to that issue?
I don't believe there are.
All right, thank you.
All right, thank you.
Thank you. Okay, next up, I don't know, is Lisa presenting on this and has she joined?
I don't know. I also don't see Justin.
I'll be promoting Lisa.
Yeah, I'm here. And I just promoted Lisa, so she should be.
Thank you, Justin. So next up on the agenda is item 3G. This is a review of the metrics under the purview of RAD and the Discipline System Statistical Report. And I see Lisa has joined us.
Hi, good afternoon, everyone. Let me share my screen. Everyone see this okay?
Yes.
Terrific. Okay. So the purpose of this presentation is purely informational to review the attached document to this agenda item, which contains data for 2021 for metrics under the purview of the Regulation and Discipline Committee, as well as our Discipline System Statistical Report. So this report contains, like I said, data for 2021, all metrics, as well as contextual data that gives context to the metrics for these 5 offices. Towards the end of the report, we also have information on post-disposition data. So on a variety of dispositions that we track, what happened to people, say 6 months out, 12 months out, 3 years out, et cetera. And then last we have updated complaining witness survey results. So let's start with OCTC. So what this table does is just summarizes our metrics, this office's metrics for the entire 2021 period. Some metrics are calculated at the monthly level, some are at the quarterly level, some are biannual metrics. And this is basically a summary dividing their set of metrics into 2 categories, because some metrics have targets that they're shooting for and other metrics don't have targets, but we simply track them. And here on the right, you can see that of all the metrics that were tracked, OCTC met their targets for all of them with the exception of 1, which was the goal was to just simply decrease the number of active respondents with a P1 case in backlog. And so the rest of these slides just simply give you a little bit of just some highlights from the report. I think in the interest of the time, I'll just kind of go through these and maybe you can ask some questions. And George Condona is also available to answer any questions you may have. But this is a chart that we've been tracking for a while now, which is just the annual caseload clearance for OCTC. And as you can see, their target is 100%. They meet it every month. This looks at caseload clearance rates year over year changes. And what this shows is that it divides the caseload by highest priority cases and lowest priority cases. And the change here is that the highest priority cases in 2021, rather than meeting a target of 100%, it was 94%, whereas the lowest priority cases, they made headway in that regard. We also track the extent to which they are processing P2 cases within 120 days. And as you can see, with each month, nearly 100% of all P2 cases are processed within 120 days. And here's a picture of what the backlog is looking like. Just as a refresher, SB 211 is calling for the ADR to be published in October of every year rather than April. And so this is what we will be reporting in October, which is that the total backlog declined by 8%. That's that number right there, 2,355 at the end of December 2021. That was the backlog number. It decreased by 8%. The next set of bars on the right divide the backlog cases into priority 1 cases versus all other cases. And the priority 1 cases in backlog actually increased by 32%. This is kind of similar, talking about those priority 1 cases. The percent of backlog cases that are P1 has been increasing over the last year steadily. And the last thing I'll share with regards to OCTC is that here's a set of metrics that we look at the quality of their work. And so one way to look at it is that the percent of Walker petitions that have been denied, and as you can see, like all petitions have been denied, were denied in 2021, and that's pretty consistent from previous years. And the chart here up on the right looks at the percent of complaint review unit reopens that were opened for reasons other than new evidence. The goal was to keep it as low as it was in 2018. As you can see, they've been meeting that goal consistently for the last few years, and including 2021. And finally, here's a metric that looks at the percent of respondents that retain representation. This is a new metric for OCTC that was put into place in response to the Professor Farkas's report and Professor Robertson's recommendations in response to his report. And as you can see, it's holding steady at around 25% of all respondents on a monthly basis are retaining representation as they go through the investigation periods and beyond. Okay, so that's OCTC. Does anyone have any questions about the OCTC metrics for now?
Madam Chair, I do have a question on that last slide. Thank you, Ms. Chavez. Good to see you again. The last slide on the respondents that retain representation, I see the jump up from 19 to 23% at the end of 2020 to the first month of 2021. There was a point at which our notifications to respondents included sort of not a disclaimer, but essentially information that, if you retain representation going through the system, you're more likely to face less discipline, et cetera. Does that coincide with that jump?
Yes, we believe so, because we started issuing that letter, I believe, in November of 2020.
Okay, thank you.
Yes. And so Dale, just thank you for asking about that. So when we first started issuing that letter, we gave it to only half of all respondents who were under investigation because we wanted to determine whether or not the letter was having an impact. Our conclusion is that it was having an impact because we compared it to respondents who didn't receive such a letter. And now all respondents are receiving that letter that's advising them to seek counsel. And so we're expecting these numbers to increase.
Madam Chair, the last thing I'll say is it's still a pretty low proportion of respondents who are able to secure representation, and we probably should look at how that affects the rest of the time going through the system. Thank you.
Okay, thank you. Okay, so go ahead.
Sorry, I just had a question about the P1 backlog. Factors has staff identified relating to that increase, and what's being done to address that?
Yep.
I don't know if Mr. Cardona wants to come up to address that, or Leah, if you want to.
Yeah, no, I was gonna just ask George to come up.
This is a good one.
So that's something we're obviously looking at. But there are a number of factors that could explain it. One is that our P1 cases, by the way we define them, tend to be the more serious cases. And as we focus our resources and define that more and are getting better at defining those cases, they are the cases that are more serious and hence are less likely to close early in the process, and so go further through the process And in addition, although I don't have the information on this, it's certainly something we could look at. But many of them, for example, if they're misappropriation cases, all factors that would typically be viewed as rendering them complex. In other words, subpoenas for bank records, financial analysis, other things. So those possibilities, but yes, it is of some concern.
I think that it was last year we received a report that showed that there were only a small number of lawyers who are responsible for those P1 cases being in backlog. And I don't know if that's a metric that we can track, because I thought that was pretty informative that that some individuals were in backlog because there were pending criminal cases and also the complexity issue. So we might want to include that as a running stat, because I think it really does inform this board fully as to why that number maybe increases. Because I mean, 30, I think what was it, 32%? It's a pretty
Yeah, and I think
substantial number.
you may want to hold that thought until we get to the next agenda item, which is a discussion of new case processing standards, where there's more analysis of kind of time effects for P1, P2, P3 cases, and breaks those down by complex and non-complex.
Any more questions for Mr. Cardona about this OCTC metrics? Okay, thank you. Okay. All right, so let's go quickly through State Bar Court. We track several metrics for.
So let me just put this on the.
Okay.
Let me just put it on the agenda. So next up on the agenda is item 3H, which is an update on plans to address the requirements contained in SB 211 that ask the State Bar to propose case processing standards. Okay, take it away, Lisa.
Okay, thank you. Okay, so this is just State Bar Court's metrics, and this is a summary on the right for it's the summary of their 2021 metrics. Basically, the biggest challenges that they're having at the hearing department, whereas we track things on a monthly basis to what extent they're processing cases within their particular case timelines, and the rest of the metrics they're meeting handily. And so I'll just skip ahead to this one just to give you a context of the hearing department. A chart like this just shows the volume of cases, the number of cases are opened versus closed. And this next chart just shows that, for the hearing department, they closed nearly 600 cases in 2021. The goal is to close 90% of them within each individual case's timeline standard. And as you can see, they met it 3 months out of the 12. But the rest of the time, these percentages say like 80%, that ultimately represents, say, missing the target by like 2 cases. And so the State Bar Court reviewed all the cases that prevented them from meeting their 90% target. And these are the reasons here on the right. And we've discussed these reasons over the last 3 years, and they all kind of fall along the same kind of bucket of reasons, which is, judicial reassignments, rejected stipulations, all sorts of reasons that are kind of related to the process. And then here's just really quickly probation. They have just one target, a metric with the target, and they met it through all 4 quarters. Client Security Fund, they have two metrics with target and one that they met. And then whereas the target to resolve at least 1,350 cases in 2021. They did not meet it. They missed it by very few cases. And then finally, here's a set of metrics for the Office of Professional Competence. A summary of their metrics is as follows. They met out of the 5, they met for 3 of them. And the second to the last, one at the top, that metric was actually paused for a variety of reasons. But the first one, they met this particular metric where they're going to have high levels of satisfaction with people calling into the hotline. They actually met that metric for 2 out of 4 quarters. And then Lawyers Assistance Programs, here's their set of metrics, and they met them all for every single time. And so again, all of these metrics, the data is actually in that report, the actual metric itself, as well as data that kind of gives context to it. So a lot of these metrics are reported at the percent level. And so what we do wherever possible, we offer an alternative chart that shows the numbers that underlie those metrics that are kind of measuring things at the percent level. Okay, and then the last part of the report is, again, something we've shared before, which is just our analysis of post-disposition outcomes. The reason why we call this post-disposition outcomes versus, say, like recidivism is that we actually are analyzing dispositions that encompasses things like receiving a resource letter and a warning letter, as well as discipline, reprovals, and probations. And we also look at 4 different types of outcomes, whether they received a new complaint again, they had a new investigation, a new case filed in the state bar court, or ultimately new discipline imposed. And so just very quickly, like if you look at, just look at like the data, we look at the data at 12 months out, 2 years out, and 3 years out. And so this is just an example of how you can quickly across all 4 dispositions, you know, how many each of these dispositions resulted in one of these outcomes that are let down here at the bottom. And ultimately what this shows is within 3 years, there's high shares of new complaints across all dispositions. So as you can see, it's like approaching 60%, no matter what disposition received. But really the biggest group of people that are coming back and receiving discipline within 3 years are the people who were put on probation. And this kind of touches upon Lori's presentation earlier. So take you down into the probation chart, how you interpret this is that this is one way to think about it. Among all attorneys who received probation in 2015, over 70% received a new complaint within 3 years. Nearly 60% were subject to an investigation, and over 30% were disciplined. So that's just one example of how you would look at each one of these dispositions and interpret the results. And then the last I'll just share with you is we have updated results from our complaining witness survey. This is a survey that goes out when a complaint is closed, and the goal is to understand how the public experiences access and fairness. We get about a 20% response rate, and our analysis compares 2 groups of complaining witnesses: people whose cases were closed in intake, and those whose cases were closed in investigation or pre-filing, because we really feel that where your case was closed will impact how you perceive the system. So we wanted to sort of control it in that way. So here's an example of the analysis of the access questions. And what we do here is show these results year over year. And what this is showing is that there's very little change year over year. This is 4 years worth of data. And this is just like a composite of all the access questions. And these access questions are actually listed, all of them in the report. And just as we suspected, this complaining witnesses whose cases are dismissed later in the process give higher access ratings, particularly in 2018 and 2020. With regards to the fairness questions, it's just a similar trend, which is that people whose cases were dismissed farther in the process, they give higher ratings. However, when you compare this chart to the previous chart, ultimately the complaining witnesses are rating the state bar lower on fairness than access. Okay, so that's all I have for now. I just want to share that my office is really reconceptualizing this report in light of a lot of things. First and foremost, the fact that the ADR now is going to be issued in October, but yet we want to get data out to you all timely. And another factor is that the ad hoc commission will be wrapping up its work this summer, and coming out of the commission is going to be lots of new metrics that are going to be tied to those recommendations that we'll start tracking. So we need to incorporate those into this report and think of how they all speak to each other, and we're going to repackage it. And then finally, we want to move towards ultimately this report being produced in something like Power BI, where you have a link and you can explore the data all different types of ways. So that's all I have for now. I'll take any questions.
Thank you, Lisa. Sorry to confuse things. We are still on item 3G.
I thought you were just teeing us up, Ryland.
I was confused. Sorry. Questions, discussion?
Okay. Thank you.
Not hearing any. Now we can have the next agenda item.
Sorry.
So next up is item 3H, which is update plans to address the case processing standard proposals as required by SB 211.
Hey again. Hi, good afternoon. I'm happy to be here and present an update for you on our work with regards to meeting the requirements in SB 211. You last heard it from us in, I believe it was September. And at that point, we just had given an overview of the path forward. And since then, my office has accomplished a lot of work in this direction, and we're happy to give you an update. And I'm here with George Cardona as well as Ron B. I'll be starting us off and reminding you of what SB 211 asked the State Bar to do. And then I'll be giving you an update of some accomplishments to date. Then I'll be turning things over to George Cardona, who's going to take us down into the framework that we've developed for these case processing standards. And the reason why George will be doing that presentation, because it really has to do with the mechanics of the discipline system. So he's probably the best person to describe that. And then we'll be turning it over to Ron B., who is our lead analyst on this project. Okay. So as a reminder, the key deliverable that SB 211 asks is that, so we propose case processing standards that, quote, reflect the goal of resolving attorney discipline cases in a timely and effective, efficient manner while having small backlogs of attorney discipline cases and best protecting the public. Right here, we said I had this crossed out because we had a change of plans recently. In September, we shared that in addition to doing this, we were going to take the opportunity to propose alternative measures to case processing standards, and we would include that in the proposal. But we decided to focus on this first and then turn our attention to this. That work is actually ongoing, but our plan is not to include it in the same proposal. So SB 211 says, or directed the State Bar to develop some case processing standards that are based on and reflect all of the following. Here it is on the right. They required us to consult with state and national experts, review case processing standards in at least 5 other states, and review reports from the LAO and the state auditor. So let me give you some updates on our state and national experts. We secured the services and the volunteers of 3 people. Robert Feldman, who's a professor at University of San Diego Law School. Reputation precedes him. I'm sure you all know him. He's executive director of Center for Public Interest Law. We also secured the services of Ellen Rosen, who's of the American Bar Association Regulation Council. And Ms. Rosen is actually serving as our national expert, and she's serving in this role as part of her role in the ABA Standing Committee on Professional Regulation Discipline System, their consulting program. And then finally, Richard Zitron has joined us. As he's a solo practitioner in San Francisco, he's a lecturer, and he was also the former chair of the Committee on Professional Responsibility. So our team meets with these 3 experts probably about once every 4 to 6 weeks over the last several months. They've helped us. They've helped us develop the framework that we'll be sharing with you. They ask very hard questions, very engaging, spirited discussions, and we're looking forward to sharing more. I think part of our proposal, I believe that they're going to be sharing their own opinions of the process and the final outcome. So Ms. Rosen, as part of her role, she's the one who recommended the 5 states that we analyzed, and here they are. She actually recommended 6. So the large states she recommended that we analyze are Texas, Illinois, and New Jersey. And what we have here is the number of attorneys that practice in those states. So it's just as a point of comparison compared to our state of California. And the smaller states are Maryland, Colorado, and Arizona. And again, Ms. Rosen is the one who did this recommendation. Okay, so the case processing standards very explicitly are to take into account the following: the mechanics of the State Bar's discipline system, risk to public protection in particular, take into account the fact that there's very often multiple complaints against an attorney, case complexity, as well as the reasonable expectations of the public for resolution of complaints. So I'm now going to turn it over to George Cardona, who's going to talk about how we incorporated the mechanics of the discipline process in order to formulate a framework to develop these case processing standards.
Okay, I'll go through each of those factors and talk about how we incorporated. So the mechanics of the discipline system. In the Office of Chief Trial Counsel, basically cases go through 3 stages between the receipt of the complaint and the ultimate filing of the NDC, which is the time period that counts towards determination of backlog, and it's the time period that's going to be used for the case processing standards. At each stage, there are some steps. So what we tried to lay out here are some of the steps which play into our assessment of what are reasonable time periods for each of those stages. So our intake stage is basically when we get the complaint, it's assigned to be read and to assess the allegations on their face. Sometimes there is minimal investigation, such as calling a complainant or reaching out to a complainant to get additional information or to have them clarify what they are actually alleging. And then the decision that's made at that point is either to decline and close it because there's no possibility of proceeding to discipline, or to prioritize it, and we'll talk about prioritization later, and refer it to the next stage, which is investigation. The next stage, investigation, is where the majority of the investigative work gets done. This group of investigators, they have assistance from attorneys, but primarily this is investigator driven at this point, with legal attorneys available to consult. There's the development of an investigation plan. There's then a requirement that we send out a notice of the allegations once we've identified the allegations and the facts that support them to the respondent, and that we give the respondent time to provide us a response. That's required under the State Bar Rules of Procedure. In this same stage, we'll also be gathering evidence independent of both the complainant and the respondent. So we may be issuing subpoenas, conducting interviews of witnesses, or where necessary, compelling people to come in for depositions. At the end of the investigation stage, the decision is basically either decline or close. And if we close here, we might impose some alternatives to discipline that you've heard about previously, as a resource letter, a warning letter, an agreement in lieu of discipline. Those are all mechanisms to close without proceeding to the next stage, which we'll get to. Or we prepare an investigative report, which is a statement of the case that goes through the facts and the evidence, and then refer it to charging, which is the final stage. In the charging stage, which is the third stage, this is primarily attorney driven. It's basically taking the information that's been gathered in the investigation and putting together the charges. So there's a charging memo and a draft of a notice of disciplinary charges. Under the rules, we are required to make an offer to the respondent to participate in an early neutral evaluation conference. And if they accept, that's set before a state bar court judge who serves as a neutral to do an evaluation and see if there's a likely potential for settlement. We then will also engage in settlement negotiations. And at the end of all of this, the decision is basically decline or close, which again might be if we close it with an alternative to discipline, or if we've managed to reach a settlement, put together a stipulation, work that out with the opposing party, and then present that to the state bar court, or file a notice of disciplinary charges. So those are the three stages that you'll see referenced in the case processing standards going to be proposed. In terms of cases closed, in the next slide from 2017 to 2021, you will see that the overwhelming majority of cases we get are closed in intake. A review determines that there simply is not sufficient allegation, and that can be for a number of reasons. We don't have jurisdiction, they're not complaining about a violation of the rules of professional conduct or the State Bar Act, but rather are essentially unhappy with the result in the case, or are alleging negligence on the part of their attorney, which is not subject to discipline. You'll also note that case age, as you look at the color codes here, case age is related to state case stage. 98% of the cases closed in intake are closed in less than 180 days, which we would expect. And that basically goes down as you move through the stages. As each stage takes more time, the time from initiation of the case when we get the complaint cumulative to the time that it's closed tends to increase. And so you'll see that trend going across. Interestingly, for all the cases that go through the different stages, 77% take less than 180 days. There's 2% that take more than 2 years. And the 2% that take more than 2 years is something that you'll see when we get to our case processing standards. Next stage related to this, and this also relates to the fact that we often get cases where there are multiple complaints against one attorney. In the investigation and charging stages, some matters can be held in abeyance as the result of pending events. So some examples, if, for example, we get 7 complaints on an attorney, and we look at one of those and say, hey, this is very strong, and the level of misconduct alleged is such that it's likely to lead to disbarment, what we may do is focus on that one and basically put the other 5 on hold. in abeyance while we are investigating the one that we think we have the strongest case as to move to disbarment, because disbarment is disbarment. It wouldn't make sense to work all 6 of those. So that's one thing. There may also be instances where the state bar is actually recommending disbarment, in which case we'll hold everything else in abeyance. There can be physical or mental incapacitation. Potentially, we would then seek an interim remedy, but we would likely put the disciplinary matter on hold. And there can also be the other situation that's common is if there's a pending civil or criminal case pending outside, the resolution of which is either necessary for us to go forward or will resolve some issues that would affect the disciplinary proceeding. And so that too can be a reason it's put on hold. We refer to these matters as abated matters. And if you've looked at the disciplinary reports over the last several years, you'll see references to abated matters. So there are a couple of policy issues that, as part of the consideration of case processing standards, need to be considered. Is our current approach to abatement appropriate? Should we do this? Another suggestion that's come up is potentially closing and consolidating as opposed to abating. So that's something to think about. And how should we report on abated matters? And as you'll see in the numbers that we've put together, we have carved abated matters out because of the time that they are on hold. They have a disproportionate impact on the overall case processing standards that I don't think necessarily reflects what we're actually doing in terms of handling the other cases. And so for purposes of the analysis, they've been carved out. But that is something that we'll need to talk about when we do the final set of case processing standards. So that's the mechanics of the discipline system, which is one of the factors that we're required to consider. The second is the risk of public protection. And here we've tried to differentiate cases on the base of our case prioritization system, which is something that is a flag that is in Odyssey that provides us with the ability to differentiate cases. That case prioritization system was put in place in 2018, and it has these 2 goals, which mesh with public protection. One, we prioritize as P1 those matters involving conduct that we believe puts clients and the public at the most significant risk. And 2, in terms of speed, we try to prioritize in such a way that we address as many allegations of misconduct as quickly as we can while still investigating them thoroughly. So we have basically what you're familiar with, which is our 3-pronged prioritization system. High-risk cases, priority 1. Attorneys who have committed serious misconduct, have caused significant or ongoing harm, or pose a risk of significant future harm, and have the ability to repeat that conduct because they're on active status or they're able to return to active status. We prioritize our resources to these currently with the goal of trying to get them all done within the 180-day backlog period. And our criteria we've set, so they were originally set to try and designate no more than 5-10% of the cases as this. In actuality, we are designating approximately 20% of our cases as P1 based on the criteria we've got in place. And then there's some examples here. P2 is lower risk, but they're expedited. So this is an effort to identify lower risk cases that we think we can resolve quickly. There may be a mechanism for resolving them with limited investigation. So for example, a classic example of this would be where the allegations in the complaint on their face state a disciplinary violation, but where we believe that a request for certain records to the respondent will get us records that will let us determine very quickly whether in fact those allegations are true or not. So for example, there may be an allegation, I wasn't paid this settlement amount, and a request to the respondent may get us a check that shows that in fact they were paid that settlement amount, which could be a very quick resolution to close that case, even though it does require investigation. Alternatively, they may require rapid investigation to determine if there's more significant harm, and they should be designated as P1. Cases that are designated as P2 on occasion are redesignated based on the result of the expedited investigation if it's determined that they're higher risk or that in fact they require more investigation. And then our final category is P3, which is lower risk, not expedited, which is basically everything that isn't in P1 or P2. So that's the prongs of public protection. The data that you'll see on the next slide looks at the case age during investigation through the second half of 2021, looks at it by each half year. And as you'll see, there's an indication that in fact our prioritization system while we're in investigation is working. We see a slight downward trend An investigation time for P1, which we believe reflects our assignment, our dedication of resources to that. The P2 times are low, suggesting that we are appropriately picking cases that can be resolved quickly. And we're seeing an increase in the P3 cases, which are basically the cases that require investigation, but that we've deprioritized in terms of resources. So this seems to suggest that our prioritization is doing what we expect. So the final kind of prong that we're required to consider is case complexity. And this is a more complex question. What are the factors that contribute to increases in the time that a case takes, which is essentially what complexity is intended to measure for purposes of the case processing standards. And so as a result of looking at data and also speaking with people in the office about what makes the case take longer, there's been these kind of 3 sets of factors identified, some factors inherent to the case, just driven by the nature of the charges and what needs to be done to investigate them, which typically are requests to outside parties for records. Factors that develop as the case goes on, if there are multiple parties, if there turn out to be multiple charges, or if the case is a major case, which means we designate, it's a high profile case that we designate for special treatment, and typically those require more approvals within the office, which slows down the processing. And then third-party actions that drive time, such as, are there requests for early neutral evaluation conferences? Has the respondent retained counsel later in the case? It's a common situation. It will proceed for some period of time without counsel, and then all of a sudden counsel comes in, which causes additional time for that counsel to get up to speed and for additional steps to be taken with that counsel. And delays in the respondent responding to our request that they respond to our letters. As you'll see on the right, approximately 20% of cases, excluding abated cases, are complex, and 80% of cases closed during the charging stage have at least one complex factor. So in other words, of the cases that actually move through and get to the charging stage, we're seeing 80% of those having one of these factors, which is not unexpected, because we would expect that the cases that go to charging tend to be the more serious cases, which in turn require more investigation and take more time. So this is an effort to correlate additional case time due to the complex factors. And you'll see that, as we expect, some of them result in more time. So the ones that take the most time, more than 4 parties. Other subpoenas, late retention of counsel, and early neutral evaluation conferences. So this is just an effort, again, to see that that happens. The final factor that we're required to look at is reasonable expectations of the public. To do this, there was a survey that was sent out to members of the public. It had 3 factual scenarios. One was a failure to perform competently. One was a failure to communicate. One was withholding settlement funds. They had different fact patterns associated with each. And there were 2 questions for each. Is it complex? Do you think this is complex? Do you think it's not complex? And then what do you think is a reasonable time to resolve it? We are waiting to get back all of the results of that. As a kind of other control for that, we're sending the same survey out to OCTC staff so that we can compare the results from the 2 different sets of individuals. The public not having experience with the system, OCTC having experience with the system, to see if that tells us anything about how to interpret the results of the public poll. We should have those results back, and we'll then add that into the final analysis. So that brings us to the proposed framework, which tries to take into account all of these factors. And basically, the case processing standards are going to consider each of these: the stage at which the case is closed, either by closure, whether with or without an alternative to discipline, or by the filing of an NDC, working through the 3 stages: intake, investigation, and charging. The risk to public protection, which we're using the case prioritization as a basically measure of, so P1, P2, or P3, and whether it's complex or non-complex. And just so you understand the numbers, pursuant to SB 211, we're not including unauthorized practice of law cases, Section 6007 from remedies matters, moral character matters, resignations with charges pending, many reinstatements or criminal conviction matters, and as I've explained earlier, for purposes of our data analysis, we're excluding abated cases so that they don't skew the results. So at this point, I think I turn it over to Ron, please.
That's probably good. Or actually, I'll do this slide and then Ron can join, okay?
Okay.
Okay, thank you, George. Okay, so as Mr. Cardona said, we're considering those 3 different components, and as a result, we ended up with 3 categories of cases. So of all cases that close, they could be categorized into one of these 3 types of cases, and it's like an interaction between those 3 different factors. And so in most cases, in some cases, intake category 1 is just all cases closed in intake. The way you interpret this chart is as follows. So right down the middle is the list of the 8 categories of cases. Let's look at what this means on the right. What this shows is that 62% of all cases that are closed by OCTC are closed in intake, or intake cases. Going all the way down to this charging, cases that close and charging in the charging stage, but they're P3 cases, they're 3% of the entire set of cases that are closed on an annual basis. So this just gives you a sense of like of these 8 categories, which comprises the biggest share. So those are all the cases that are closed in intake. And then throughout these, so for example, category number 4, 10% of all cases closed are cases that are closed in investigation, for their P3 cases and their non-complex cases. Okay, on the right is our analysis of, for each of these categories, what is the median case disposition time in days? And as you can see, starting at the top, of all cases closed in intake, the median time to close is 33 days. As you go down this, it's a typology basically. As you go down, cases are taking longer to close. With the longest, the one with the highest, longest number of days is the category 7 cases, which are cases that are closed in the charging stage, but they're P1 cases, 493 days. That's the median. The way you interpret median is that half of the cases are closed earlier than 493 days and half above. Okay.
And if I can, just to come back to the question from the earlier agenda item, we believe that that's driving the increase in P1 cases in backlog.
Okay, so now it's time to, okay, so this is our proposed framework, is that we would propose case processing standards for each of these categories of cases that OCTC works with. So now I'm going to bring in Ron B to give you, to explain a little bit more about this and to show our estimated case processing standards. Okay, can you promote Ron, please?
He's promoted.
Okay. Okay, why don't I see him? Okay, Ron, are you ready?
Yes, I just unmuted.
Okay.
After looking at all of those factors, the next step was to really see how we could come up with 2 sets of standards. The 2 sets of standards, the first one is to look at what happened in the past and see how all of these factors drive the case disposition time, so that we can set a standard that reflect as is situation without changes in current resource level, but likely to introduce some procedural operational changes to improve efficiency. That's one set of standards that we can get started. Followed by a second set of standards is to project the relationship between additional resource and improvements of the case time. So the first step is to come out with as is, and then we'll look into the second one. Later on, we'll present the as is preliminary standards that we came up with. In terms of the standards, how we measure the time, there are 2 different ways, and we'll look at both. One is the average or median time, and that's typically how, in representing the case time or any kind of a continuous measure, you will look at median or average. The second is quite often used as time standards, which is the % of the cases closed within a certain time frame. And here we look at the 90th percentile and look at the time that we think we'll be able to achieve that standard. Next. So in relation to the first set of standards, looking back into the past, we pull the data from the 4 years where we have all of these factors, including prioritization, complexity factors, and then the stage of the case closure, and calculate the median time for each year and see what the distribution is like. You can see here, it's a range corresponding to the amount of time each category of cases take. The first 3 categories, intake, investigation P2, investigation P1, but not complex, the median time shows that they're all closed within 180 days. And then looking at the last 2 categories, the charging stage cases, they exceeded 360 over 1 year. And the remaining of those categories, they were closed in terms of median time between 6-7 months and 1 year. So that gives us some idea about the distribution of the case time over the past few years for these categories. Similarly, looking at 90th percentile, moving to the next slides. 90th percentile, you see similar patterns. However, you can see the time being stretched out over. It's because moving from median measure to 90th percentile, here for almost all of the groups, the amount of time doubled or more than doubled. As a result, you see here more cases in the from the 3rd to all the way to the 6 categories, investigation, P3 complex, they fall beyond 1 year. And then as indicated earlier in other slides, the last 2 stages, the 90th percentile time went beyond 2 years. So that's looking at the spread of the case time in 2 measures over the 4 years. Here is another way of trying to understand what caused the time to change over the 4-year period. Now, instead of looking at all of the years, we took the first year and previous years. In between, there's a lot that happened, contributed to the change of the time. And first of all, what the chart represents using what's called the box whisker plot. The box represents the middle 50% of the distribution. And the vertical line that you see in each of the category, it represents median time. And the whisker at the end of the lines, it represents what's typically considered outliers. So beyond those whiskers are cases that's in outlier situation. So this chart comparing the 2 years, you can see not only the change in the median time, but also the spread of the distribution. Starting with the first, if you click on it to show the, can you click to show the first category?
Oh.
Yep, going back. Focus on.
Sorry. Oh, sorry, Ron. Sorry, I'll just point to it. How's that? Just right here?
Yeah.
Okay.
Focus on a comparison of the first group, P2 cases investigation. You can see over the past 4 years, not only the median time, but also the spread of the time had improved in comparison between 2018 and 2021. That indicates the improvements in identifying and processing the expedited cases. And now looking at the second set of cases, we can focus on P1 cases closed investigation. The 2 sets of P1 cases, complex and non-complex, between 2018 and 2021, the median time didn't change much, and the spread actually were reduced a little bit, meaning that there's some efficiency in processing P1 cases while they were closed in investigation. And if you look at 4 and 6, group 4 and 6, those are P3 cases closed in investigation, including both complex and non-complex, because they were lower priority cases. The median time increased a little bit, especially for the complex one, but also is stretched out a little more in 2021 compared to 2018. And then the last two groups, they are the most complex cases going all the way to the charging stage, the median time, as well as the overall spread, and the outlier cases, all of them took longer. Now, a lot of these is clearly a reflection of the prioritization system, but also remember between the two time period, what happened that would contribute to this change include in late 2018 and early 2019, a pretty significant increase of new complaints coming in. And then early 2019, the start of the Odyssey implementation, that probably will take 1 to 2 years or more to get everything into the same kind of efficiency that's expected. And then later on, we also have 2019, the fingerprinting project that increased a lot of criminal conviction cases. So many factors contributed to the change between the two time periods. Taking into account all of these is what we're going to do next to come out with the as-is standards that reflects the current situation without resource change.
Okay.
So you have seen the categories, the numbers, the percentages here in the tabular form. In the middle part of the table, you see the minimum, maximum, and average of the annual median time over the past 4 years. And this is methodologically to establish as-is standard is to look at the trend over the past 4 years and compare to the current situation, current as represented by 2021, working with OCTC to see what's reasonable to set as a preliminary standard. So the numbers in the red column is what we propose as preliminary standards. This is reviewed with the experts, and it also were consulted with the management at OCTC. So all of these is just the starting point, reflecting what happened in the past, and then some improvements in the process is hoping that could serve as a preliminary, as its standards for median cases.
Ron, if I could just jump in, just to make sure this is explicitly clear. Right now, we have a statutory standard that says we're going to close a complaint or file a notice of disciplinary charges in state bar court within 180 days for a non-complex case, 12 months for a complex case. So that would be 365 days. What you see there in the red is the proposed revision to the 180-365 paradigm in a scenario where there are no new resources afforded to OCTC. So because we're proposing 8 different categories for case processing time standards, right now there's no categorization. You see several that are at or under the 180 days. It is only when you get to the cases in the charging stage that you go beyond not just the 180, but also the 365. That's one thing I want to highlight. The other is that you can see that the proposed standards in red is particularly down in rows 7 and 8, and row 6 are lower than our current median times. And maybe George can speak a little bit to that, but that's his sort of work that he's committed to doing to increase the efficiency within OCTC, even without new resources. Do you want to talk a little bit about that?
Yes, that is it. That's what we are going to try to do. You'll note much of this is driven, as Leah pointed out, if you look at the investigation phase, you'll see that the proposed standards would have cases that close in the investigation stage, all close under the 180 days, at or before the investigation stage, all close under 180 days, except for P3 complex cases, which would still fit within the current 365-day timeframe. It's really when we get to charging that we're moving outside of that. And that's largely a function of the fact that there are just a lot of things that have to be done before a case can be charged, some of which are completely outside our control, such as, those tend to be cases where we will have multiple communications with the respondent because there's a resistance to being charged, provision of additional information. A large number of those are cases in which attorneys request ENECs. There may be multiple ENECs. We may, again, even in the charging stage, have to deal with additional information the respondent provides, incorporating that and figuring out what is the appropriate thing to charge. So I think that those numbers make some sense once we break it down this way. The other thing I would urge people to note is that the actual number of cases in those two stages is very, very small. It's the number of cases that actually proceed to charging. So the vast majority of the cases under these standards are, if we meet them, again, if we meet them, going to be closing, well before 1 year is up. So looking at these and having consulted and done some looking back at some of the other work that's been done, including in particular the 2016 backlog study that was done, the workforce analysis that was done then, and some of the work that's been done since then, these numbers are not out of line with that work and with a realistic evaluation of what has to be done to get a case to the finish line in terms of actually charging it. So our hope is that we can do some things to meet these, and obviously we'll see. And again, these are medians, and Ron's going to show you another slide that is going to make you more unhappy, which is the 90th percentile numbers.
Okay.
And before he does that, I should just note, so that there's some more comfort here, is that in looking at other states, which we've been doing, other states invariably report their time standards in terms of medians. They look at their median case times, not at their 90th percentiles.
So median represents half the cases meeting certain standards at that point. And it's also just a half measure if you don't consider the entire distribution. So the virtue of the new standards we proposed and the advantage of for differentiated kind of a case categories is you see the full picture, not only in terms of distribution at median, but all the way to 90th percentile, but in terms of the case categories, depending on all of these different factors. The 90th percentile time overall, it varies significantly from 60 days for intake cases all the way to 900 days for the last category, roll number 8. So this is based on our evaluation of the distribution of the cases across the categories over time, and that working with OCTC that were deemed to be achievable. And then the next stage is to just evaluate to what extent additional resources would improve the process and the efficiency more in order to come up with the enhanced case processing standards. So without any additional question, we can go to the next slide that had all of the additional factors we have to consider. So far, we talked about the empirical data, driving the evaluation of the patterns and trends over time so that we can come out with as-is standards. And then George also mentioned the previous workforce studies looking at the focus group and survey results and potential effects of the operational and other management adjustments that we can have some insights that will impact the case processing time and potential effect on fairness and other part of the process. All of those will need to be taken into consideration. And consultation, the other factors are required by SB 211 that we take into consideration, including consultation with state and national experts, consideration of case processing standards from 6 other states that we have actually reviewed. And a lot of times we don't see the full picture, only some of it has to do with the categories that we created. And also to consult with the findings from the previous LAO reports and state auditors reports in the past few years. Survey of the public, and we expanded it to survey also the OCTC staff and other sectors of the government. So for example, some of these California agencies, regulatory agencies, they also have their standards. We're going to consult to all of them in order to come out with the next set of standards that's aspirational, enhanced with staff resource associated with it. So that's the end of our presentation.
Well, thank you all for such a comprehensive presentation, and clearly a ton of work has gone into this. Discussion, questions?
I've got a question, Madam Chair.
Yeah.
It's sort of random. With respect to the SB 211's requirement that we survey the public and see what their expectations are with respect to our work and your works, your office's work, George. Was that just like a random sampling of anybody in California, or is it folks who we know have been in the legal system represented by attorneys or needing representation by attorneys? Can you share any of those details?
So I think Ron has that information.
We relied on social media campaign. The social media campaign using Facebook, LinkedIn, I think, also Twitter. We post the message asking people to participate in the survey. And based on the responses so far, including the question about whether they are attorney or not, whether they have had experience filing a complaint with the State Bar, the majority are members of the general public, not attorneys. And then the majority, they didn't have experience filing complaints with the State Bar. So how representative of the entire state adult population, it's hard to say. It's partly driven by the social media campaign, drawing the people to participate in that survey.
But we do think that's consistent with SB 211, which does just call for reasonable expectations of the public, not for some limited subset of the public.
In the way that we designed the survey to lay out 3 vignettes, and especially after comparing the results with some preliminary responses from OCTC staff, we're pretty confident the assessments of the public reflects valuable information that we can consult. For example, the complexity rating reflects the vignettes that we presented, it's different scenarios, what we consider to be complex. It's consistent in their rating about the complexity. And more complex cases also had a longer estimated time of case processing standard that they evaluated. And the preliminary results from the public is also similar to results from the OCTC staff, although with some very interesting differences as well. We're still getting responses at this point.
I don't know if other trustees have questions or comments. I wanted to say that we, right when I came back to the board last July, there was an agenda item to approve a case processing standard proposal that went forward to ledge staff, and it was rejected. This is our second bite at the apple now, so to speak. And so I think, although I know that was a very long presentation, it's a lot, it's way in the weeds. I do think it's important that you all understand and agree, at least in some policy sense, with the decisions that we're making. For example, to propose case processing standards at a level of in 8 categories. Okay, that's a sort of a fundamental change from where we are today. To propose an as-is standard that does reflect essentially what we are doing today in terms of timelines, with some, adjustments and improvements for that very small subset of cases. But that's a policy decision to make. I know, Ruben, you commented to me that the numbers look quite high, particularly at that 90th percentile, looking at 900 days, even though that's a very small percentage of cases, even though it's a 90th percentile analysis, it has a shock value. So that's something the board needs to be comfortable with. And certainly as we move to populating that next column, where we're going to say these are the aspirational standards, and this is the resource level we think we need to get there, the board needs to be comfortable with that as well. We all need to be confident that if we get those resources, we're going to actually be able to meet the standard. So just wanted to pull back a little bit and say, this is why this is being brought to you, because there are very important decisions here to make. And then one other piece before I stop talking, our intent is to bring a finalized proposal to you in May. So that it can then be submitted to the Legislative Analyst's Office and the state auditor potentially in time for consideration by legislature in the 2023 fee cycle, hopefully.
Just to follow up on what Leah just said, it's important for the board to sort of wrap our heads around this, get comfortable with it and commit to it. And also, quite frankly, it's imperative for you and your office, Mr. Cardona, and then for all of us collectively to be able to communicate the changes that we're talking about, which are fundamental changes to the way the state bar has been viewed historically. Because when you tell the story the way you told it to us today, it's not even a story, it's just a recitation of how things actually happen. It does take on a different sheen. It seems more realistic and reasonable. And at the same time, we're still holding ourselves to a higher standard when it comes to demarcating those goals. And as I can see it in your face, right? If we make this shift, we have to be sure that it's something that is meaningful and reasonable and possible for you and your staff, given the resources that we have. And that's just more an editorial comment than anything. I don't think it's a question, but certainly I would love to hear your reaction if you have one.
Yeah, no, I mean, I understand that. I mean, that's one reason why, when we looked at the median times and the 90th percentile times, we looked at the data over time. And I do think that there are some things, and we've had some discussions within OCTC. I do think there are some efficiency improvements we can make in how we handle cases. There are some things, and I think, there are some things that an investigation, the process is never going to be as quick as people think it should be, because there are just some things that have to be done and some things that take time. When we cut a subpoena for records, if we cut a subpoena for records, we're basically saying, okay, we're adding 30 or 45 days to the time frame. When we make a request to a respondent for information, we're basically saying we're adding 30 days to the timeline. And so there's a trade-off, which I think everybody recognizes, between time and thoroughness and necessary steps in the investigation. I've talked at length, and again, I think it's important to remember that these are probabilistic standards. They're not that 100% of cases will be done in these timeframes. An advantage of a median standard is that it leaves more wiggle room. The 90th percentile, I think, potentially gives people more information in terms of the number of cases that are going to fall within that. But I have talked with the managers, and we do think that there are things we can do to meet these standards, even with our current resources. One of the primary drivers, and one of the things that we'll be looking at in terms of the proposed standards for additional staffing, is just the fact that when attorneys, and in particular investigators, are carrying large numbers of cases, there's necessarily time lost as they move back and forth from one case to the other, and potentially, work one case, then have to jump to another case. Then when they come back to that first case, there's a time to get back up to speed on that case. And so as you move over the larger and larger the caseload gets, the kind of natural trend is for every case in that caseload to take more time. So that's what we'll be looking at in terms of the proposed standards and staffing, and an effort to cut that down. But even if we were to go to investigators and attorneys having one case, if that, which is impossible, but if that case is still going to take time, depending on the type of case it is. So that's a long-winded answer, but yes, I understand that we need to commit, and yes, I think we can do some things that will get us to these standards.
Madam Chair, I have a comment. First of all, I want to say thank you. I appreciate the very granular understanding, but I would offer this. because we were denied initially, and now you're going back at another bite of the apple. I hope that within this process, prior to finalization, that there is a temperature check to just ensure that people are comfortable with the direction that you're moving in without revealing everything that you all are doing. Because what would be, with all the work that has been put into this, it would be unfortunate to get to the end and find again that we have not kind of met where they'd like us to be. So I would just offer that.
And I guess that raises a question too in my mind. Are we able to articulate in this presentation how this new proposal addresses any shortcomings, if any, that or the reasons why the legislature rejected our first proposal, if any were given, right? Is there a way to say, we've heard you, we, went back to the drawing board and here's what we did to address those concerns?
I think so. So last year, the rejection was basically all you've done is tell us what you can currently do, right? You didn't make any adjustments, absent. You didn't make any adjustments irrespective of a request for new resources. So that's the standard that we proposed, is basically what we can do. That's the only thing we proposed. We did not also propose an enhanced standard with a corresponding resource request. So I think, frankly, we were not responsive to what we were asked to do last year, in all honesty. So that's one way that this current methodology or approach is responsive, is that we are going to give them an as-is condition that does reflect slight improvements, but also we are going to give them the to-be state, what we believe are appropriate case processing standards. So that's one way we're responsive. Also being responsive to some of the methodological concerns raised in our workload study, particularly by the Legislative Analyst's Office. So trying to do that as well.
Okay.
And the explanation as to how we get to the enhanced standards will encompass references to prior auditors' reports and some of the comments that they've made and some of the analysis that they did. So I'm hoping that will be persuasive.
Great. Other comments, discussion? Okay, we're going to take this up again in May, right? Okay. With an even longer presentation.
Oh,
No,
well,
heard this part. Now we can condense it down.
All right. Well, thank you.
Thank you.
Went into this. Thank you, Lisa and Ron.
Thank you.
Okay. I think that brings us to the end of our open agenda items. And so now we will go into closed session to take up 2 items on the closed session agenda.
That is correct. And Mark and Arnie, I sent you the closed session link.